All right, hi everyone.
I'm
Welcome back to our So Far So Good live with PropertyLimBrothers. And my name is Melvin. Hi, Adrian. How are you doing?
I'm great. So how many more weeks are left for the circuit breaker to end?
I think another 4 weeks to go. 4 weeks to go.
Yeah,
Hopefully by
can't wait.
1st June, yeah, we'll be back to normal. And yeah, thank you everyone for tuning in with us on a Saturday afternoon at 12 p.m. With Property and Brothers. As usual, we will be holding our Saturday 12 p.m. session all the way until the circuit breaker is over, and then most likely we'll resume to our podcast show on every Wednesday. And thank you for tuning in with us. Now today we have a very special guest, and she's a lawyer with Simontek and Partners SMT&P. Simontek specializes in family legacy planning, estate probate, will, trust, as well as property law and conveyancing. So today we'll be having Jacintha with us shortly, and later at the last part of this segment, we're going to have a bit of Q&A. So if you're joining us at any point in time, feel free to put in your comments, questions down below. And the main thing that we'll be chatting about today, together with my almost real brother Adrian, with Jacintha, is that we'll be asking her questions about legacy planning, about trust, about will, about probate. Is that right, Adrian?
Yes, exactly. We'll be asking her some of these very interesting questions about legacy planning and probate. Yep.
All right, and we think that this is a very important part relating to owning properties in Singapore, because planning is definitely important, especially for your next generation. Is to have a more concise plan, and I think a lot of people forget about this segment whenever they buy a property. And yeah, it would be great having Jacintha on the show. So why don't we have her in right now?
Hello.
Hey, hi, Jacintha.
Hi, Jessica.
Hi.
Hello,
Hi.
hello. Welcome,
Hello.
welcome to our So Far So Good live show. How are you doing today?
I'm good. Thanks for having me.
All right. Yeah, so just now we have briefly introduced you to our audience. Right. Maybe for the sake of our audience, why don't you share with us a little bit, like, what do you do? How long have you been in law practice?
Okay, so I have been practicing for 20 years now.
Right.
With Take
Oh,
and
that's a long time.
Partners. Yeah, I know. People don't really believe it sometimes, just from the way I look. But yeah, that's true. I have been with Take and Partners for about 13 years now. Yeah.
Right.
Right. Yeah, and for these 13 years, what do you mainly specialize at Simonte? I understand you are a senior partner, and you guys also hold a lot of webinars during this period to educate your consumers. So yeah, usually what do you specialize in on a
Okay,
day-to-day
so
basis?
I do a lot of real estate work. So conveyancing is a big part of my portfolio, and legacy planning is a natural spillover from conveyancing. So that is another very big portfolio because when clients buy properties, they invest, they need to plan, and so we tell them that's a very important thing to do. So I help clients in their wills, their trusts, and then of course another natural thing that happens is people pass on, right? So we also do probate. So wills, trust, probate, and real estate work. Yeah, that's
Right.
what under my profile.
Right. Great. Yeah. So before we go into all the nitty-gritty questions about will, trust, probate, and the big topic about legacy planning. So just to understand, like, for your day-to-day job scope, what do you usually do? I mean, especially during this circuit breaker season, how is life being a lawyer?
So circuit breaker is really different. It's something that we have never experienced. At least I've never experienced, right? So day to day, it's when you go to the office, it's packed meetings back to back. I basically see clients one after the other, do drafting, emails, and stuff like that. But now with this whole different arrangement, we don't get to see that many clients. But because we have exemption to operate, when it comes to time-sensitive matters like our completions, exercise of options, we still need to do that, and we still see clients for these matters. So from time to time, I'll be in the office, attending to clients, signing off letters. But when we are working from home, we do a lot more Zoom calls with clients, right? So we keep in contact with them via Zoom calls. I'm sure you're familiar.
Yeah.
That is a very
The rise of Zoom,
correct.
especially over the 6 weeks.
Yeah, and we've also been doing a lot of webinars. So in the past, we used to have talks and sessions face-to-face with our working partners and clients, but now we conduct webinars to just ensure that this contact is still there, so that when things go back to normal, we're not lost.
Right. And you mentioned that you specialize a lot in doing conveyancing, and family legacy is actually like a part that naturally evolves. Like so when did you start to dabble into family legacy? Has it been the start of your portfolio since 13 years back, or what have you noticed, like over your 13 years, does it come out as a popular thing in recent years only, or like in the past is it
I guess in the recent years, I think there's a lot more awareness, and people are looking into it. I mean, you can see that in the news, right? People are talking about dying and what to do and planning. So it's become a topic that is a little bit more spoken about. In the past, maybe not so. People don't really like to talk about it, maybe because it's a different generation as well. But I always tell my clients that your property will outlive you, right? Even if it's a leasehold property. So we have to plan. And dying is not a question of if, it's a question of when. So it's reality. So I kind of take it from a very practical approach. So we talk about it as an important planning process. Dying is something that you have to acknowledge and you have to plan for. Yeah. So
Yes, but you also never know, when death comes about.
yeah, exactly.
No one can predict.
right? So maybe for the context of today's session, where we talk about family legacy planning, how do you define legacy planning? What is this big thing that people have been talking about?
Okay, so legacy planning is all about planning for transferring your assets, your legacy to your loved ones upon your demise, right? So legacy is basically what you own, whether it's your assets, your property, your bank accounts, even things like your values and your belief system. All these are your legacy, right? Which you will not be able to take away with you. So because you cannot take it away with you, you should plan for the transfer of those to your family. So that basically is legacy planning.
Right.
I see. That only apply to the high net worth.
Yeah, so I do get a lot of response from clients like that as well. They say, "Oh, I don't have much. I have nothing, so I don't need to plan. Only the rich need to plan." But I disagree, because, like I said, legacy is what you leave behind, right? For some people, it could be substantial. For some people, it could be modest. But nonetheless, you will leave something behind. Even if you have one property, that's your legacy, right? So if you don't plan for it, then you will not be able to ensure a smooth transition. So legacy planning is not just for the high net worth, it's for people who care for their loved ones. I think that's important. That's where you should really look into legacy planning.
Right. Yeah. So estate planning is a part of the legacy planning a portion. So do you think that everybody will need an estate plan?
I guess estate planning, legacy planning, they're used quite synonymously with each other. Legacy could probably be wider than estate planning, in the sense that it could encompass things like what I mentioned earlier, your value system, your belief system. But for simplicity, people use it quite interchangeably. Estate and legacy, it's about the same thing. It's really, I mean, in our context now, it's probably your assets, what you leave behind.
Yeah, and do you think that it is wise for everybody to have such a plan? And maybe for people who have not explored this kind of planning before, is it expensive to do an estate plan?
Okay, so when you talk about planning, you're talking about drafting your will, Okay, at the very basic, you should have a document called your will, which helps you to set out your wishes on how your assets are to be distributed when you pass on. For some people, it could include a trust. So you could either have a trust embedded within your will, we call it a testamentary trust, or you can have a trust now in your lifetime. So depending on the profile of the clients, their specific needs. So these are the usual tools for legacy. Now, apart from your will, the other very important component for planning is the lasting power of attorney. So that is actually to talk about, when people lose mental capacity, who's going to take over their affairs and manage things on their behalf. So that one strictly is not about wealth transfer, but it's a very big component of planning because aging is something that we cannot run away from, right? And with aging and even not aging issues, but people can lose their mental capacity even when they're young, due to unforeseen accidents or coma or stroke. So when these things happen, you need to plan in advance, right? So that's where you have your LPA, your lasting power of attorney. So when clients come to us and they ask how do we plan, we explore these two very important documents, your will and your LPA.
Right. What happen if let's say I die without a will? How would my assets be distributed within my families?
Okay, so if a person dies without a will, they die intestate. Okay, so the law will determine how their assets are to be distributed. So the law that we're looking at is called the Intestate Succession Act. So basically, if you have a will, your will talk about how you want your assets to be distributed. But if you don't have the will, the law will help you determine how your assets are to be distributed. There are fixed rules on distribution.
I see.
Yeah.
Then it may not be the best best outcome for me. Like what I want for my family then.
Yeah, I mean, it may not be the best outcome or it may be suitable. It really depends on the specific situation. So, generally speaking, the Intestate Succession Act makes a distinction between people who are married and people who are single, right? So, if you are married, then different distribution method. If you're single, different distribution as well. So, I give you an example. If a person is married but no children, okay, upon demise, half goes to the spouse, the other half goes to the deceased parents, right? So imagine young couple, professional, they have no kids. They also think that they don't need to do a will because they're young. But if something would happen to one of them, immediately the spouse gets half, the parents of the deceased gets half. So in that situation, it may not be ideal, right? It may not be something that they anticipated. So planning is important. Yeah.
Yes, indeed.
Right. And if let's say somebody sets a will for their assets, is the will contestable?
Definitely the will can be contested. Several reasons, grounds for contesting a will. Sometimes it's due to undue influence. So it could be a case where someone is challenging your will because they said that you got it drafted under duress, somebody influenced you unduly. It could be on the basis that the person who drafted the will lacked mental capacity. So maybe they were very old or they were under certain medication and they didn't have the necessary capacity. So on that grounds, it can be challenged. It can also be challenged on the basis that it was not drafted clearly, so on the basis of ambiguity. So these are the usual grounds a will could possibly be contested.
I see. Like, what are probably some of the cases that you've seen before, and usually how do people resolve that?
Okay, so I don't do litigation, right? But I can preempt clients. So example, if I see very elderly clients and they come and they tell me that they want to get their will drafted, of course we have to we have to check, to see whether this client has mental capacity to give instructions, testamentary capacity. So the minute they are very elderly, we're a bit cautious, right? Because we're not doctors. So we'll ask them questions, to assess their alertness and their ability to give us the instructions. Now, if there is any ambiguity, maybe they're not very clear or they're a bit confused, or if they tell us that they want to exclude certain family members, then what we would normally do is we will say that we would prefer these clients get a medical report, right? See a doctor to ascertain that they have full testamentary capacity. And if the doctor is able to verify that, then we will be able to continue and take on instructions, because I guess we are concerned that if something happens, the will gets challenged, it's not going to be a pleasant outcome, see. So from a practical point of view, we tend to do that. So this is just an example of when you would probably want to take extra precaution as well.
Right, and usually when the will is done, who keeps the will?
Okay, so when the will is done, it will be given to the client. They will take it. They will have custody of their own will, and upon death, the original will needs to be presented to the court to enable the family to apply for probate. So the will be given back to the client to keep.
Okay, great. Yeah.
Can anyone be executor? Or any advice on who?
Okay, so the executor is basically the person who steps into the shoes of the deceased to take over and to apply for the court order, which is the grant of probate, to call in the assets, to distribute according to the wishes of the testator, right? So in terms of how do you choose your executor, you would usually want to choose somebody that is trustworthy, somebody that you're very close to. Depending on the terms of your will, sometimes it is also important to appoint somebody who is financially independent, same set of maybe values and practice. But generally speaking, based on experience, most of the time clients would choose executors based on the fact that they are close family members or very good friends of theirs.
So this person basically takes care of the execution of the will after you're gone.
Correct.
So it can be a family member, right?
Yes, it can be a family member.
Okay, but will there be like conflict of interest if part of the assets are being distributed to this particular family member who also happens to be the executor as well?
Yeah. So
Usually-
we often get that question as well. The idea that a lot of people have is if you're a beneficiary, you cannot be an executor. Well, there is no issue for the beneficiary to be the executor as well, but in certain circumstances, there could be a conflict situation. For example, if the will of the testator says that I want to give my beneficiary all these assets, okay, but I want it to be held in trust for this beneficiary until he is, say, 30 years old. And then if you put that beneficiary as the executor, then obviously there's a conflict, right? So you, under those circumstances, you may not want to do so. But if it's an outright gift, say I upon my death, I give everything to my wife. My wife can be the sole executor, she can be the sole beneficiary, then there's no issue with that.
I see. So in cases where there's a trust involved, then it might get a little bit more complicated.
Yeah, exactly. So it really depends, and that's where the lawyers will be able to advise on how you should structure, who would be the ideal candidate and things like that.
I see. Okay, I think this becoming like a education session on the legal terms and stuff. Okay, so maybe Jacintha, for the benefit of our audience, can you explain to us like what is the definition of a probate? Because just now you mentioned about probate, you also mentioned about lasting power of attorney. So some of us might not be very well versed with all these definitions. So what is probate in a simple layman term?
Let me try and explain. Yeah. So basically, when a person passes away, things don't automatically get transferred to the beneficiaries. Okay, there has to be a process. So the process is to get this court order called grant of probate. So when grant of probate is obtained, the person who is named in the will of the deceased, who is the executor, he's the one who applies for the grant. He then has the power to take over and manage everything. So with the will actually facilitates the obtaining of the grant of probate. So that's the probate. So when people pass on, very naturally you will talk about probate.
I see.
Yeah.
So the executor actually takes the will and then apply to court for the grant of probate so that he has vested power to execute what is written on the will.
Yeah.
Okay,
So example, they need to sell a property, right? You cannot just take the will and go and see your agent and say, can you please sell the property? I have the will, right? It's not good enough. You need to go through the whole probate process, obtain the court order. With the court order, you can then instruct the relevant people to do what is required for the estate.
Yeah. So usually, how long does this process take? Like applying to court for a court order, the grant of probate?
If it's straightforward, not too complicated estate, maybe about 3 months or so, you can get the probate obtained. But if it is a very complex situation, it could drag on.
I see.
Right.
Yeah.
Is there a difference between administrator and probate?
Yeah. So like I mentioned, right, when person passes on, you need to get a court order. Now, if you have a will, the court order that you'll be obtaining is called the grant of probate. Now, when a
Okay.
person dies without a will, you also need a court order. Okay, and that court order
Right.
is called grant of letters of administration. So
Oh,
it's the
okay. I got.
grant of letters of administration. So if a person dies without a will, then the family will have to apply for the letters of administration to enable them to administer the estate of the deceased.
Right.
Ah,
Yeah. And that's based on the intestacy law that you just mentioned.
Correct.
Okay. Right. And coming to just on the other question, what is the lasting power of
LPA.
attorney? Yeah, and what's the difference between that and the power of attorney?
Okay, so the lasting power of attorney is actually a document that allows you to appoint somebody to act on your behalf if you lose mental capacity. Okay, so loss of mental capacity could be due to things like old age illnesses, Alzheimer's, dementia, which we're all concerned about because we're an aging population, right? But it could also be due to things like accident leading to a coma, or somebody has a stroke and that affects his mental capacity. So once the person loses mental capacity, he cannot make decisions on his own, right? But life goes on. So who can then step into his shoes to help him take over his properties, his bank accounts, even things like making his decision on where he lives, what kind of medical treatment. Now, if he did an LPA, a lasting power of attorney, the person appointed is called his donee. So the donee can then step into his shoes to take over and manage all these things. So that's what an LPA is. It's another planning tool.
I see.
Yeah.
I see. So
The other question was difference between LPA and POA, right?
yes.
Okay.
Yeah.
So power of attorney is the POA for short. POA allows you to appoint somebody to help you manage certain affairs. Usually, if you are traveling or you're not around, but you need things to be handled in Singapore, maybe your property matters, you will do a power of attorney for your attorney or your donee to act on your behalf. But the difference between POA and LPA is this. If a person loses mental capacity, you cannot use the POA anymore. There's no more power. So that's where the LPA comes in.
Okay. Right. So now that we have gone through some of the terms and legalities that you mentioned. Okay, so maybe to simplify, let's say somebody just bought a property, right? They just bought a property and they come to you guys for conveyancing and stuff like that. And then they ask you, hey, I want to set up this whole estate planning, right? So what are some of the definitely must have, after they have bought a property, what are some of the definite must have that they need to set up in terms of the tools that you mentioned? That means number one is this, number two is this, number three is this. And what are these few items and how much usually do they cost for a person who just bought a property to set it up?
Definitely, when you buy a property, I always tell clients this is probably one of your biggest asset, right? And you need to plan because you can't take your property with you. Even if it's a leasehold property, it will outlive you, like I said earlier. So you need to plan, and you definitely would want to ensure that it passes on to your loved ones in a very smooth manner. So that document that you need to draw up is called your will. Right? So the will allows you to plan on how your property, not just your property, but all your other assets will be distributed to your beneficiaries upon demise. So we know death is a certainty. So for sure, you need to do the will.
Okay, so number one is the will. All right.
So that's the will. Then the second document is the LPA, because loss of mental capacity is something that we cannot anticipate, right? Whether it will happen or not. But if it does happen, and if you have, say, property under your name, you will no longer have the capacity to manage those properties. So, for example, if we take the scenario of somebody elderly, right? They own real estate. If they have Alzheimer's or dementia, they can no longer make decisions. Now, property decisions still have to go on. Maybe the property is being rented out. Who's going to sign the tenancy agreement? Maybe the elderly person needs medical care, and the only way to obtain funds is by selling his assets, his property. Who can sell the property? Who can sign the option or the sale and purchase agreement? Somebody has to step into his shoes. So that is where the LPA is extremely important. So if you have an LPA, you had already pre-decided, okay, I'm going to appoint my son to take over. So he can then, with that document, step into your shoes and take over all your affairs. So that's where the LPA comes in. Although it's something that we don't know for sure whether it will happen to us or not, but because there is always this risk, an LPA is just as important. I normally tell my clients, will and LPA.
Okay, so these two, in your opinion, are the must-have, the will and LPA. So coming to the LPA, can there be two LPAs?
No, you can only have one LPA. But the LPA will handle your personal welfare and your property and affairs. So it covers two broad areas, right? Personal welfare means your day-to-day decisions like your medical, your healthcare, where you stay, your standard of living. Your property and affairs will deal with your real estate, your bank accounts, your investments. So that's basically what your donee can manage on your behalf.
Right. Okay, great. So if you have just tuning in with us at So Far So Good PropertyLimBrothers Live, we have Ms. Jacintha from SMT&P, and Partners. Today we're talking about family legacy planning, or in another term, estate planning, and it's especially important, especially for people who are planning to buy a property, or you have already owned properties for many years but have not really had the time to sit down and do some planning regarding your estate. I think it's a very interesting topic, and Ms. Jacintha has been an expert in conveyancing and family legacy for the past 13 years. So ladies, if you have any questions for Ms. Jacintha, please feel free. If you're watching over Facebook or YouTube, or even if you're on Instagram, you can head over to Facebook and YouTube to key in your comments down below. So Adrian, what other questions do you have for Ms. Jacintha?
Yes, I think we have some very interesting questions, and since we are on this will topic, maybe Miss Jacintha, any advice on where should I keep my will or my LPA?
Okay, so the will be given to you, and you will have to safekeep it, right? So a lot of times people, the first place that comes to mind is their bank safe. So ironically, it's not the best place to keep your will, because if you are the only person who has access to the bank safe, then upon your demise, it's basically stuck. And you need the will in order to obtain probate, but the bank will not allow you to access the safe without the probate. So do not keep it in the bank safe if you are the only person who has access to it. The will should be kept in a place that is safe, where people cannot tamper with. So I normally would tell clients, maybe it's a good idea to get a fireproof home safe, keep it at home, put all your important documents in there, right? So your will and all your title deeds and things like that are important. Keep it in the home safe.
I see. Would we be able to keep it with our law firms?
Yeah, that's the other alternative. You can also get your law firm to safekeep your document for you. Now, because the will is such an important document, you do not want people tampering with it and all that. So you should be in safe hands. So if you foresee that your home is not a suitable place to keep it, you might want to safekeep it with your lawyer. That's also an option.
Right.
So we have another very common question. So for example, let's say somebody has passed on and they're holding on to, let's say, a landed property, and they are planning to distribute this to 3 of their kids. And 2 of the kids own HDB properties, and the other one own a condominium. All right. So the common question is that this landed property that's being passed on to the 3 kids, do they definitely have to sell, or can they hold it? And will they incur ABSD as well?
Okay.
Yeah.
So that quite a few things in your question, but I'll try and break it down. Firstly, the property, if it's bequeathed to the 3 children, assuming in equal shares, they can get themselves registered as the owners of the property. But if one of them has HDB or two of them have HDB, then at that point, if according to the prevailing rules under HDB, they cannot own landed property, then they cannot. So the decision probably would be they have to sell the property or redistribute the shares. If they have existing properties and they inherit this landed property, even if they inherit 1/3 share in that landed property, it adds on to their property count. Okay, so if they already existingly have a HDB and then their parents pass on, they inherit 1/3 share in that landed property, they're treated to have two property counts. Okay, then the question of ABSD and stamp duty. Now, if they inherit the property pursuant to the will, or even if they inherit it pursuant to the law, which is the Intestate Succession Act, then there will be no stamp duty payable or no ABSD payable as well. But like I said earlier, it adds on to their property count. So although they have inherited only 1/3 share, it's treated as an additional property. So if existing property is HDB, inherit 1/3 share, so they would then have two properties. When they buy the next property, when you compute ABSD, it would be as though they're buying the third property. Okay, so at that point, it will be relevant. Then I think the last question is when they sell, right? SSD. So SSD is seller's stamp duty. So this is also a very common question that clients will ask us. Like, I inherited a property from my dad. If I sell it now, do I have to pay seller's stamp duty? Now, seller's stamp duty is applicable if you acquire the property within the SSD period. So, for example, if you bought a property last year, then if you sell it within 3 years, you have to pay seller's stamp duty to the government. Now, when it comes to inherited properties, the date of acquisition is actually the date of acquisition of the deceased owner, right? So if let's say your dad acquired the property very recently, within the seller's stamp duty period, and he passed on, you take over the property and then you sell it. And you sell it within that SSD period, counting from the date your dad originally bought the property, you have to pay SSD. But if it is something that he bought maybe 10 years ago, you inherit it today, then you don't have to pay SSD when you sell it.
Right. So it's based on the date that the deceased bought it.
Yeah, exactly.
Yeah. So coming to deeper part of that question, just now you mentioned that if let's say a HDB property and this is assuming that if you have owned it for 5 years already, you have fulfilled your minimum occupation period. Then let's say you have owned a property for 8 years, and to make things simpler, let's say you inherited a private property from your parents solely, right? And it just passed on to one kid only, and this child has owned a HDB for 8 years. Now they are inheriting a condominium, so they can technically hold it because they have fulfilled their minimum occupation period. Am I right?
We got to check with HDB on the rules. So if let's say it's one of those where you bought it in the past and it doesn't come under it's out of the MOP, and HDB. So if at that point in time HDB says no, you can't, they will normally give you about 6 months to get rid of your property, to dispose of the inherited.
So the reverse question always comes. For example, if a child owns a private property, and then their deceased parents pass on the HDB property to them after their demise. So what happens? I mean, do they get to choose, should I keep the HDB or the private, or they definitely have to sell the HDB?
Okay, so usually HDB, when that happens and they want to transfer to the beneficiary, and the beneficiary at that point in time does not meet the eligibility requirements of HDB because they own a private property, they cannot hold the HDB, then HDB will tell them you need to dispose of it within 6 months. So that's where they will decide, do I want to dispose of the HDB or do I want to dispose of my private property, and they will do their planning at that point. If for whatever reason they cannot comply with the time given by HDB, then it would be important to go back to HDB to ask for an extension, to appeal for an extension so that they can organize their matters.
All right.
Okay.
Adrian, you seem very deep in thoughts. What question do you have?
Yeah, I was thinking, let's say if I have a jointly owned property, not with my family but with some partners, and can the will be included in the joint property?
Okay, so in Singapore, there are two different manners of holding of properties. So you have joint tenancy and you have tenancy in common, right? So joint tenancy, I'm sure you're familiar. Joint tenancy is a concept where there is right of survivorship. So,
Yeah.
for example, husband and wife own the property under joint tenancy. If husband dies, everything goes to wife automatically. So that is called right of survivorship. Now, the other manner of holding that we have is called tenancy in common. So, tenancy in common is where you have a distinct share in the property. So, for example, tenants in common in equal shares, it means each has 50%. Okay, so in your scenario, if say you have a property with a friend, they will usually choose tenancy in common. So, if it's a distinct share, then you can include it in your will. So your will can say, I give my share in the property, it could be 50% to my family, right? But if it is a joint tenancy property, then it's not so straightforward. So I give you an example. Maybe husband and wife have a property under joint tenancy. Husband says that if I die, I want in my will to say all my assets go to my son. Okay, all my assets includes my property. But if that property that he owns with the wife is under joint tenancy, upon his demise, that property doesn't fall under the will to go to the son. It will go to the survivor, which is the wife. So under those circumstances, it doesn't fall under the will. Does that
Right.
answer your question?
Yeah, because joint tenancy supersedes that portion, right?
Yeah, because the survivor takes over and it doesn't go under the estate of the deceased. But if it's tenancy in common, then it can be distributed under your will.
Okay, so coming back to another question, which was spin off from what Adrian asked just now. So Jacintha, let's say for example, two friends they went to a show flat and then they bought a property together. Both are single, both are buying their first property together, and they are buying under tenancy in common. And let's say they're doing a 50-50 share, all right, 50-50, and both went ahead to set their will. So person A set their will to to one of their family member. Person B went ahead to set their will to one of the family member, and then one day one person passes away. So person A passed away, and the family member takes over that 50% share. So in this situation, if one person wants to sell, so now these two person they are one is the surviving friend, the other one is a family member. So if one person wants to sell, but the other person don't agree, what is going to happen? I mean, what right to both people have?
Okay, so they have to come to a consensus, right? One cannot sell without the other. Even if one owns 1% share, the other one owns 99% share, there's no right of majority, right? So both have to come to an agreement on what to do. Now, based on experience, most of the time when one passes away, the usual thing that will happen is they will sell the property and they will split the proceeds for the simple reason that the property is usually under mortgage. So if there is a loan over the property, then you don't really have much of a choice. You will probably need to sell the property and settle the loan first and then split the proceeds equally, right? But if let's say one wants to keep the property, then the option is to buy over the other share from the deceased owner in order to take over 100%. So that could be something that they may want to explore. But definitely you can't override each other, or one doesn't have
More say than the other. Yeah,
exactly.
so I think back to a very important point is that even if one person owns 99% and the other person owns like 1%, if the person holding 1% do not want to sell, there's also nothing that the 99% person can do, right?
Yeah, exactly.
Right.
So if it's complicated, then you probably have to go to court and try and get it resolved, but that will be a separate issue altogether.
Okay. Right. Yeah. Adrian, do you have any other questions for Jacintha?
Yes. What happens if I have a client who has overseas and locals assets, right? So can his overseas will be written in Singapore, or is it better to have his will written in different countries? Let's say, example, one in Malaysia, Indonesia, and Singapore. So can one local will does everything?
Yep. Okay, so also very common question that clients will normally ask. your will, if the will drafted in Singapore covers all your assets, which includes your overseas assets, then it can be executed, no problem. Okay, but
I
if
see.
your will covers only the Singapore assets, then you would definitely need to ensure that you have separate instruments for your assets in other countries. Whether one will or separate wills would be more suitable really depends on a couple of factors. So it will depend on things like how extensive your assets are in those jurisdictions, how long you plan to keep those assets for, is it long term or short term, whether you have where your assets are being located, in which jurisdiction, because different jurisdictions there might be different implications like tax exposure. Okay, so I'll give you an example. If client has assets in say UK, okay, in UK, if it's above a certain threshold, they will have to pay inheritance tax. In Singapore, in Malaysia, for now, we don't have inheritance tax as state duty, but in some countries they do. So I'm giving you the example of the UK. So they have inheritance tax if it exceeds a certain amount. Now, if the client says, I want to include my UK property in my Singapore will, they can. But as a lawyer in Singapore, we will not be in a position to advise the clients on the UK law, on the tax exposure that they may face. So under those circumstances, it may be a good idea for them to seek legal advice in the UK, because the lawyer there would be able to tell them, okay, maybe you can consider a certain structure, how to minimize your tax exposure, what is the most efficient way to distribute. So that could be a benefit and advantage in separating the wills and have UK cover UK, Singapore cover Singapore, right? But if let's say client says, it maybe Malaysia, I have a bank account in Malaysia, it's a small account, it's just a very small part of my entire portfolio. I don't think in these circumstances I want to go to Malaysia and draft a will and see a lawyer there. Then of course we will include it in the Singapore will, and that's fine.
I see.
Right.
Wow. After having this session with you, I think will is important. I better go and see if I have a will.
Have you got your
So
will? Adrian, where do you keep your will?
I do not know, man. I need to go and find it.
Is it in the wardrobe behind you?
I think so. Let me go and dig it
Yeah.
out. Yeah.
You can
So
see it.
where should we? Yeah, where should we do will or lasting power of attorney in your
When
opinion? Yeah,
when
where should
Should we do it immediately after I purchase the property?
or at what age?
Yeah, so it's not the usual resistance we get from people are things, I'm still young, I don't have much. But to me, as long as you have something, as long as you have assets, you should plan. And your will is definitely not one document that will last you your entire lifetime. You will be going through a few wills in your lifetime. I have changed my will I don't know how many times, because I keep changing my executor, right? So you need to understand that a will evolve with your circumstances. So it's best to start young, right? The minute you have certain assets, you should already start planning. And then maybe when your circumstances change, maybe you acquire more assets, you will have different ideas. Or if you get married and then you start to have children, you may have different considerations. So that's where you need to perhaps update your will again. And then later on in life, when your kids grow up and then they get married, you have grandkids, you have different considerations. So the will is something that will evolve through your life. So you should start young and then keep updating it as you move along. There is no optimum time to do your will, because we don't know when we're going to expire, right?
Right. So final question for Jacintha before we head to the Q&A session. Let's say somebody approaches your firm and they want to have this entire package, what you mentioned, like will plus lasting power of attorney. How much is the rough cost involved, like, to set for this entire thing? Like do case by case basis or stuff like that?
Yeah. I mean, I would refrain from talking about fees online. So maybe if you could take it offline, no problem. But it really depends a lot on the complexity of the document. Is it a straightforward or complicated will? And every firm has a different
fee rate and stuff.
Rates, yeah, exactly.
Sure. So it's more like a case by case basis, depending on the complexity and things like that.
Yeah.
Okay, great. All right, so I think we can kickstart our Q&A session. So if you are just joining us, we have just chat with Jacintha from Simon & Partners regarding family legacy or estate planning. If that's what you know about planning your will and lasting power of attorney after you purchase a property. So it's a very important topic, and it has gained a lot of popularity in recent years because people are not now more open to talk about death and planning for the next generation, leaving your assets in proper. And I think it's a very important part of investing in the property as well in Singapore. So if you have any questions, we are now open to questions, and you can just feel free to keep in your comments. So Jacintha, are you ready for the questions?
Yes, I am.
Okay.
After
Safi, do
this
you
session,
have
I
any
would like
questions?
so after this session, I would like to fix an appointment with Miss Jacintha to plan
Happy to
my
see
will.
you. Happy
Can we
to
do
see
it?
you. We'll take it
We can do
offline.
it immediately, Adrian, like after this.
Sorry?
You can immediately meet Jacintha after this.
No, cannot. Circuit breaker.
No, let's do over Zoom. Let's do over Zoom.
Yeah, we can do over Zoom.
And East Line.
Okay,
Oh, that's great.
so right, we have a question from Justin. Justin is asking, is it possible to have just one will that covers properties in different countries? What
Okay,
is
so I
it?
think you asked me that question earlier, but for the benefit of Justin, let's go through it again. So, like I said, you can have one will that covers properties in different countries as long as your will is drafted to include those assets. But it may be advantageous to consider doing a separate will in separate jurisdiction. So if let's say your assets are in certain jurisdictions where there are tax considerations, then it's good to seek a lawyer's advice in that jurisdiction because he may be able to advise you on how best to structure the distribution to be the most efficient. The other advantage that I did not mention is when it comes to probate, if you have wills in separate jurisdictions, it could be faster in the sense that your probate can be obtained concurrently. So if let's say you have a will in Singapore, you can obtain the probate in the Singapore court. Now, if you have a will in Malaysia, you can obtain probate in the Malaysia court concurrently. So you don't have to wait for one to be completed before you go to the next jurisdiction and sort out your affairs. So that could be an advantage as well of having a separate will in separate jurisdictions. But nothing wrong with having one will to cover all assets.
Right. Okay, great. Hope that answers your question, Justin. So the next question from Alison Jane. I have a question. If there are two owners under tenancy in common, say 99% and 1%, can the 99% owner cede full control of the property to the 1% owner perpetually and irrevocably, such that 1% owner can decide when and how much to sell, and if this agreement can survive the transfer of 1% to another owner? So if you're wondering why is Melvin reading out the questions, because this episode will be aired on our podcast as well on Spotify and Apple iTunes. So we're just reading out for the sake of our audience right there. So yeah, Justina, go ahead.
Okay. So if there are two owners under tenancy in common, well, in terms of this question, there's actually a lot of trust implications, which is quite a separate discussion and can get quite convoluted. But a straightforward answer would be 1% owner, 99% owner cannot give full control to the 1% owner because you both have rights to decide on how to deal with the property, like I mentioned earlier, right? And you should not have any agreement to give perpetual and irrevocable control unless it's some sort of trust arrangement that you have. But in terms of the document that can allow the 1% owner to manage, sometimes people do power of attorneys. So if they do a power of attorney, they can give each other power to take over to manage the property. But of course, the power of attorney must be subsisting and not revoked. Okay?
Right. Okay. Great. Thanks, Alison, for joining us. Hope that answers your question. Do you have any more questions? All right, so we have one from Marcus Ryan Tan. Following on the previous question, if both own 50% of a property and both don't have the financial ability to buy out each other, and one party really wants to sell, insists to sell, what does the court usually decide?
If both own 50% in the branch.
Yeah. So
Okay,
I think
yeah, so they have to, it's a case by case, they have to present it to the court on what basis they should sell the property. Most of the time, like I mentioned, they are usually loan considerations. So they don't even have the priority goes to the bank, right? So once the person passes away, it triggers this mortgage risk and priority goes to the bank. So if it's a case where there's a bank loan, you need to keep the property, you probably need to refinance the facility. And it wouldn't make sense for two people who are, kind of unrelated to go and refinance the loan together, because there are other considerations like your TDSR and all that. So the usual practical thing would be to sell the property. So I guess the court will look at all these considerations as well. Right? And most of the time, it will probably just be a sale of the property, which would be the logical thing to do.
right. Okay. Thanks, Marcus, for asking that question. Do you have any other questions for Jacintha? Okay,
Yes,
so
we
questions
have.
from Adrian, maybe we can.
Yeah, so we have questions from Lee Tiong Chun. He asked, so joint tenancy still needs a will?
Okay, so joint tenancy means survivor takes all, right? So if one goes, the surviving owner takes, and if there is a will, that property doesn't follow the will of the deceased. But if both are deceased, then you will still need the will. And I mean, sometimes people are concerned about things like accidents happening, plane crash, that kind of situation. So even if it's a joint tenancy property, you may end up being the sole owner, and that's where your will determine how it's to be distributed. So on that basis, even if it's a joint tenancy property, we should still include it in a sense, but whether it will actually be distributed depends on whether you end up being the sole owner of the property or there is a surviving owner.
Yeah. So, Jacinta, what if, let's say a couple, they bought a property together and it was executed as a tenancy in common first, and then maybe subsequent years down the road they decide to say, I want to change to joint tenancy. Is that possible? And vice versa, is that possible as well?
Okay, so usually it would be joint tenancy, they sever it to tenancy in common, right? So if you originally own the property under joint tenancy and you want to sever it to make it tenancy in common, you can only do it 50-50. That means it can only be tenancy in common in equal shares. Okay,
Right.
so
you
if it
cannot
is
do like 99-1 and stuff.
no, you can't. So if it's a 99-1, you can't change it to a joint tenancy situation. So, I mean, this is also a very common question from clients, because sometimes they may want to like sell their share to each other to decouple. So originally they own as joint tenancy. Then they will ask us, can we split 99-1? You can't. It has to be severed 50-50. So it becomes tenancy in common in equal shares.
Right. Okay. All right, so we have another question from Alison Jane again. So Alison is asking a follow-up from my earlier question. Can a POA be irrevocable and also be able to survive passing on 1% share to a new buyer?
Okay, so POA cannot survive death. Like, when a person dies, the document that will come into effect is the will. Okay, not your LPA, not your POA. Right? So it cannot survive the passing. We generally do not draft irrevocable power of attorneys.
Right. Okay.
Because power of attorney can be revoked if the person has already lost mental capacity by virtue of the law and when the person dies, right? So definitely the power of attorney is not a will. It cannot survive death.
Okay.
See.
Yeah, so Adrian, go ahead.
No.
Okay,
Go on.
so Jacintha, if let's say somebody's decides to come to your firm and they want to set up the will and lasting power of attorney, usually how long does this process take? Like what is the period that all this can be completed?
So we kind of take this whole legacy planning quite seriously, because we recognize that everybody's circumstances are different. There is no one size fits all, right? So we would need to understand your family situation, your needs, your background, what assets you have, so that we can properly advise you on how to structure it. Usually, the whole consultation process will take about an hour. So within an hour or so, we should be able to have a meaningful discussion with the client, capture their instructions, and then we can start the drafting. So the drafting, of course, depends on the workload of the lawyer, but most of the time within a week, we should be able to get your will drafted. And if there's an urgency, then we can meet you shortly after to get it signed. So all in all, the whole process, if you allow us to take the lead, probably it can be done within 2 weeks, getting your instructions, drafting, and then arranging for the next appointment to get it signed.
Right. And I understand that your firm has also a special department that helps clients, whereby you call it your private practice, family, legal services and stuff like that, where you deal with everything that a family will need in terms of their needs when it comes to planning or even like immigration and stuff like that, right?
Yeah. So we have private clients practice because we help a lot of clients, high net worth clients, in their transactions. So their matters, they will basically instruct us to advise them on. So from the things like the acquisition of their properties to their PR matters, trying to get a PR or immigration into Singapore, handling their family offices, setting up their family office, helping them to get employment pass and dependent pass. All these things would fall under the private client practice.
Right. Okay, great. All right, since we have some one more question that came in by Jonathan. So Jonathan is asking, is it possible to transfer ownership in a joint tenancy from an owner to another owner without monetary consideration for HDB flats?
Okay, so for HDB, you can do a gift. If you comply with the terms, you can do a gift transaction. So you can transfer for this kind of transactions, you probably get HDB to help you. Yes, you can do it without monetary consideration, and that is basically a gift transaction.
All right. Okay. Thanks, Jonathan, for asking. Adrian, do you have any final questions for Jacintha?
Yes, I do have. In fact, I have a lot. Okay,
Okay,
just
maybe
one
one
last one.
final question before we let her
One
go.
final one, All right. Okay, so what should one do if they want their estate to last for many generations?
Okay, so very common approach would be to set up a trust. Okay, so you can set up a trust where you basically transfer your assets into a trust managed by the trustee, and the trustee will help you deal with it to distribute to the beneficiaries, and it depends on the instructions as well as the size of the estate. I suppose if you want it to last several generations, right? So it's possible. You can also, of course, do it through the will, but depends on your instructions to the trustee as well. But I think ultimately, this is something that you have to we talk to clients and deal with it on a case by case basis. Size of the estate definitely is important if you want it to last a few generations, but it can be done.
Right.
Okay.
I do hope I can last for many generations.
Okay, so maybe sidetrack from the legacy planning part. So just want to pick your thoughts, Jacintha, before we let you off for the session. So, pertaining to the COVID-19 situation around the world, this pandemic right now. I mean, myself and Adrian, we joined the property industry about 14 years back. So I still remember when we joined around 2007. That was already sort of like in the middle of the subprime crisis. And so the biggest one that we have encountered was 2008 Lehman Brothers crisis, right? So right now with this pandemic going on, how do you think, like it would change the way that people communicate, or, based on your conveyancing experience, how do you think that it would change the property market and things like that? Like what is your feel on the ground, or what is your little prediction of the market?
I think it has forced us to use technology overnight, right? Things that we never expected to be doing, we're now doing on a daily basis. Talking to clients on Zoom calls, when in the past we would say, no, you have to come to the office. We cannot talk to you over the phone, And then even giving seminars and presentations, it was always face to face, but suddenly now everything is done telecommuting, remoting on a remote basis. So I think it changes the way that we work. It creates a whole new platform. So if you look at it from the positive side, I think there are a lot more opportunities, and it gives us the platform to reach out to our clients, our overseas clients, and clients under all sorts of circumstances. So it's an evolving process, and I think we learn along the way. And I think that, like you shared earlier, right, about how viewings can be done virtually and all that. So
Right.
as soon as people start getting used to this new technology, a whole new way of doing things, I think we will be fine. But it is nonetheless a tough situation that we're facing, and let's see how it pans out.
Right. Right. All right. Okay. Thank you so much for coming on to our session. It is great having you. And I think today we answered a lot of in-depth questions pertaining to estate planning. It definitely helps us in our audience to understand more about some of the terminologies as well. So really great to have you, Jacintha. And
Thank you.
again, if you want to know more about Jacintha and her firm, Jacintha is a senior partner at Simontek and Partners, SMT&P Law, and your office is at HDB Hub, Toa Payoh, right? Am I right?
We have two offices. We have one at HDB Hub Toa Payoh that does the HDB transactions, and then we also have office in Paragon where I am, and that's where we deal with more of the high net worth clients cases as well as other private property transactions at the Paragon office.
Right. So if you'd like to know a bit more about Simontek and Partners, we will be inserting their links and some of their information right in the description down below. And of course, thank you for coming on stream with us at PropertyLimBrothers Live. So far, so good. We will see you on next Saturday, 12 p.m. again without fail. And in the meantime, everybody stay safe, take care, and
Thank you.
yeah, thank you, Jacintha. Yeah, we'll
Thank
see
you.
you.
Have a
Thank you.
good weekend.
Take
Bye.
care.
You too.
Bye. Bye.
Bye.
Bye.